Name?
The beneficiary.
Yeah, first name, Mr. Beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking you what your name is.
my name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm going to recall him. Bring up somebody else. Put him aside. We'll call him at the end.
Thank you, Judge.
All right, who's next? DDC.
Do you want Pollard back?
Pollard?
That's the last one. Homicide.
Does he have his mind right? Sir, is your name the beneficiary, Kevin Teron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I asked the questions here. You give me yes or no answers.
You're asking for my permission to
ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
This is the classic sovereign citizen playbook. Kevin Pollard refuses to even acknowledge his name, calling himself the beneficiary of a trust. It's more than word games. It's a tactic to derail the court's authority. Watching the judge try to pin him down on a simple yes or no question shows how these arguments collapse under real legal pressure.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor. It is you.
Really?
Yes, Your Honor. It is you. That is
Kevin
Pollard. Yes, Your Honor.
Kevin Pollard.
You are Kevin Pollard today, Your Honor. I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
I have. Can I speak to the clerk before we go any further?
You know what? I'm gonna put you in timeout. Get your mind right. Mr. Pollard?
Yes, sir.
Here the judge finally snaps. Notice the shift in tone. I ask the questions, you give the answers. The patience runs out, and in real time you see the courtroom reasserting control. For viewers, this is the moment the beneficiary persona stops working and the court's authority reclaims the space.
You will give an opportunity. Let me finish. While this case is pending, there's no contact with no person contact, no contact with third parties, no phone calls, no emails, no text messages. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct 1st degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. And my belief in all that is because these victims all live out of state. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot who, the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old. What are you doing? And he says, well, we're playing video games. So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that the Mr. Pollard touched her, and she asked him to stop, and that's when they left. Now, what happened is, though, when he was asked that question, if he did do that, he goes, well, I carried her into the bedroom. My hand may have rubbed up against, he says, okay? He said, you know, accidentally. The situation is she's told, the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 10/23/2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS Tabular if he's ever be able to post bond, Your Honor. Thank you.
Okay. One question, Council.
Now we get to the truly disturbing part. Prosecutors outline a pattern of online grooming and an alleged incident with a 7-year-old child. This is where the story goes from odd to horrifying. In your video, blur the child's name, mute or lower the audio for graphic specifics, but keep the tension. It explains the high bond and why the judge is so strict.
So these charges for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he did not actually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask this court consider a high personal bond, if not that, 10%.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard.
Defense tries to humanize Pard. A 4-year-old case, no conviction since, local business owner, parent. This is your contrast moment. The defense's calm tone against the state's portrait of a predator. Viewers should feel that tug of war. Is the defendant truly misunderstood or simply manipulating the system?
Is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her vagina with his hand. This court is not considering the other cases that were dismissed. They were dismissed without prejudice. Okay, this court is only going with this man, this gentleman, the defendant. Bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today is the 26th, January 29th. 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a creditor in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the, again, the unaffordable bond redetermination for this Monday, January 29th, 2024, 9 o'clock in front of Judge McConigal. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary.
Here's the decisive gavel moment. The judge lays down the $250,000 cash bond, GPS tether, house arrest, and no contact with minors. Calling him a predator is rare judicial language. It's not just a procedural ruling, it's a label with weight. End your video by underscoring how serious it is for a judge to use that word on record.
Also known as Kevin Pollard. Madam Clerk.
Pretrial, Your
Do you
Honor.
want to talk to the gentleman that's in front of the screen?
Judge.
Okay.
Pretrial and
Just so for the
examination.
record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not
concludes his
fair.
arraignment. Thank you.
That is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you can go. Go ahead and do whatever.
You cannot do that.
Okay.
As the beneficiary,
have those dates again?
I asked the
I'm sorry.
Can we have those dates again? We couldn't hear them.
Over the dates.
February 2nd, February 8th.
February 2nd, February 8th. Bond
the clerk
redetermination Monday.
administrator of this SUV QV trust account that she
Finally, the outburst. Despite the formal ruling, Pard still yells about rights violations and not my judge. It's a perfect coda, from sovereign citizen rhetoric at the start to open defiance at the end. Your commentary can emphasize the irony. The more he invokes trust law, the less trust the court has in him.